All right, guys, welcome back to the channel, the Butterfly Monkey Effect. Hopefully you guys are caught up on all 8 videos, the prior videos that I made on passports and the right to travel, a study of administrative controls on the citizenship. Of course, this is a government document, 1966 when it was published. You guys can easily find this on my Telegram if you guys want to read it yourselves and so forth. So to continue on court cases still, we left off right here on Zemo versus Rusk. And he goes on to say, so Zemo versus Rusk, May of 1965. After this country had broken diplomatic relations with Cuba, and the Department of State had eliminated Cuba from the area for which passports were not required, Appellate applied to have his passport validated for travel to Cuba, to satisfy his curiosity and to make him a better informed citizen. His request was denied, and he filed suit in the federal district court seeking a judgment declaring that he was entitled under the Constitution and the laws of the United States to travel to Cuba and to have his passport validated for that purpose, that the Secretary of State's travel restrictions were invalid, and that the Passport Act of 26 and Section 215 of the Immigration and Nationality Act of 1952 were unconstitutional. In addition, he prayed that the Secretary and Attorney General be enjoined from interfering with such travel. A 3-judge court granted the Secretary's motion for summary judgment and dismissed the action against the Attorney General. And then it says from the head note, the questions for decision are whether the Secretary of State is statutorily authorized to refuse or validate the passports of United States citizens for travel to Cuba, and if he is, whether the exercise of that authority is constitutionally permissible. We answer both questions in the affirmative. We think the Passport Act of 26, and then he said the 1958 edition too, so they updated it, embodies a grant of authority to the executive to refuse to validate the passport of the United States citizens for travel to Cuba. That act provides, in pertinent part, the Secretary of State may grant and issue passports under such rules as the President shall designate and prescribe for and on behalf of the United States. This provision is derived from Section 23 of the Act on August 18, 1856, which, of course, that's the original, right, power, which had prior to 1926 been reenacted several times without substantial change. The legislative history of the 1926 Act and its predecessors does not is true, affirmably indicate an intention to authorize area restrictions, and there is no legislative history indicating an intent to exclude such restrictions from the grant of authority. These factors take on added significance when viewed in light of the fact that during the decade preceding the passage of the Act, the executive had imposed both peacetime and wartime area restrictions. The court thereafter cited numerous examples. Even if there had been no passport legislation enacted since the 1926 Act, the post-1926 history of executive imposition of area restrictions, as well as pre-1926 history, would be of relevance to our construction of the Act. The interpretation expressly placed on a statute by those charged with its administration must be given weight by courts faced with the task of construing the statute. Under some circumstances, Congress's failure to repeal or revise in the face of such administrative interpretation has been held to constitute persuasive evidence that the interpretation is the one intended by Congress. That's there, you know what I'm saying? There, the administrative interpretation. which, they're not supposed to do. They're not supposed to interpretate the statute. But he's saying because Congress never did nothing about it and changed it, this judge is going along with the interpretation of the administration to be correct. In this case, however, the interference is supported by more than just congressional inaction. For in 1952, Congress substantially reenacting laws which have been passed during the First and Second World Wars provided that after the issuance of a presidential proclamation of war or national emergency, it would be unlawful to leave or enter the United States without a valid passport. Section 215 of the Immigration Act of 52. The Solicitor General urges that in view of the issuance in 1953 of a presidential proclamation of national emergency, which is still outstanding, travel in violation of an area restriction imposed on an otherwise valid passport is unlawful under the 1952 Act. The correctness of this interpretation is a question we do not reach on this appeal. But whether or not the new legislation was intended to attach criminal penalties to the violation of area restrictions, it certainly was not meant to cut back upon the power to impose such restrictions. Despite 26 years of executive interpretation of the 1926 Act as authorizing the imposition of area restrictions, Congress in 1952, though it once again enacted legislation relating to passports, left completely untouched the broad rulemaking authority granted to the earlier act. So, meaning the discretion of the Secretary of State. It must be remembered in reading this passage that the issue involved in Kent was whether a citizen could be denied a passport because of his political beliefs or associations. That's key word, beliefs, not activities. In finding that history did not support the position of the Secretary in that case, we summarize that history so far as material here. That is so far as material to passport refusals based on the character of the particular applicant. In this case, however, the Secretary has refused to validate appellant's passport not because of any characteristic peculiar to appellant, but rather because foreign policy considerations affecting all citizens. So it's completely two different, the context is different. One is a belief, your own opinions, and this is foreign affairs. In Kent, we held that the right to travel is part of the liberty which the citizen cannot be deprived without due process of law under the Fifth Amendment. See also Aptheker versus Secretary of State. So I'm guessing this is another case. I thought there was just one. I'm going to have to find the other one. However, the fact that a liberty cannot be inhibited without due process of law does not mean that it can, under no circumstances, be inhibited. The right to travel within the United States is, of course, also constitutionally protected, Edwards versus California. But that freedom does not mean that areas ravaged by flood, fire, or pestilence cannot be quarantined when it can be demonstrated that unlimited travel to the area would directly and materially interfere with the safety and welfare of the area or the nation. And this is like, see, that's one thing I think I don't understand either, right? Because they are saying, like the California fires, right? They weren't letting people even going back to their house, right? Okay, well, how the hell does that give any state interest, compelling state interest for not to go there, right? For not letting, the homeowners go there, right? And it says it like right here, would directly and materially interfere with the safety and welfare of the area, right? To me, that's of the area or the nation. Like, what are you talking about? We're cleaning up our stuff. We're actually doing better for the area and the welfare of that area that just got burnt down. You know what I'm saying? So it's like, I don't know. Some of it like, the rationality doesn't make sense because the compelling public interest is not there, or to me, it's not strong enough. Like it's like it's petty as hell, and or arbitrary, and it shouldn't even be a reason. So it is with international. So it is. Let me make sure. Or the nation as a whole. So it is. So it is with international travel that the restriction which is challenged in this case is supported by the weightiest considerations of national security is perhaps best pointed up by recalling that the Cuban Missile Crisis of October of '62 preceded the filing of an applicant's complaint by less than 2 months. We must agree that the Secretary's refusal to validate passports for Cuba renders less than wholly free the flow of information concerning that country. While we further agree that this is a factor to be considered to be in determining whether appellant has been denied due process of law, we cannot accept the contention of appellate that it is a First Amendment right which is involved. I don't see how. They didn't say his job. They didn't say he was like there on business, like a newspaper journalist or something. Just for his own curiosity, he said. For to that extent that the Secretary's refusal to validate passports for Cuba acts as an inhibition, and it would be unrealistic to assume that it does not. It is an inhibition of action. There are few restrictions on action which could not be clothed by the ingenuous argument in the garb of this decreased data flow. For example, the prohibition of unauthorized entry into the White House diminishes the citizen's opportunities to gather information he might find relevant to his opinion of the way the country is being run. But that does not make entry into the White House a First Amendment right. You can already see where his argument is failing. The right to speak and publish does not carry with it the unrestrained right to gather information. Finally, appellant challenges the 1926 Act on the ground that it does not contain sufficiently definite standards for the formulation of travel controls by the executive. It is important to bear in mind in appraising this argument that because of the changeable and explosive nature of contemporary international relations and the fact that the executive is immediately privy to information which cannot be swiftly presented to, evaluated by, or acted upon by the legislator, Congress, in giving the executive authority over matters of foreign affairs, must be necessity paint with a brush broader than it is customarily wielded in domestic areas. Practically every volume of the United States statutes contains one or more acts of joint resolutions of Congress authorizing actions by the president in respect to subjects affecting foreign relations, which either leave the exercise of the power to his unrestricted judgment or provide a standard far more general than that which has always been considered requisite with regard to domestic affairs. This does not mean that simply because a statute deals with foreign relations, it can grant the executive totally unrestricted freedom of choice. However, the 1926 Act contains no such grant. We have held in Kent and reaffirmed today that the 1926 Act must take its content from history. It authorizes only those passport refusals and restrictions which it could fairly be argued were adopted by Congress in light of prior administrative practice. So limited, the Act does not constitute an invalid delegation. Read in the context of arguments appellate makes here, it appears that the intent of the complaint was that these latter prayers should be considered only in the event that the court decided that the Secretary lacks authority to refuse to validate appellate's passport for Cuba. However, the complaint can also be read to incorporate a request that even if the court should find that the Secretary does not have such authority, it goes on to decide whether appellate can be criminally prosecuted under 215B of the Immigration and Nationality Act of 52 for travel in violation of an area restriction. That section provides, after such proclamation as is provided for in subsection A has been made and published, and while such proclamation is enforced, it shall accept as otherwise provided by the President and subject to such limitations and exceptions as the President may authorize and prescribe, be unlawful for any citizen of the United States to depart from or enter or attempt to depart from or enter the United States unless he bears a valid passport. A proclamation of the sort referred to was issued in 1953 and remains on the books. Proclamation 3004, which is something I don't recall really reading. Like if right now we go under, let's see, the DS-11 form, right? Let's see what we find. DS, damn. I probably have one somewhere, but you know, fuck it. Let's just find one. This is probably not a good. I know it. Oops. Give me a second. Really, like, can I get a fucking blank form here? Wow. Like, I can't even, you know what I'm saying? It's like ads instead. Well, search, dude. Wow. Can't even fucking get a proper one. Look at that shit. Just give me a fucking form, man. Like, why don't the government website come up? Like, I don't understand. Like, look at, why is it like the 5th or 6th one? I get the PDF right here. Use our form filler. No, form filler. I'm going to download the form right here. Oh, come on, man. That was renewal. So that's this one. Okay. Sorry about this. Man, some of this shit's retarded. Okay, so we're going to go under the authority section. Let me zoom in right here. Well, it's the Privacy Act statement, right? So these are all the things. Collection of this information is authorized by all these sections, right? So you have outside of statutes, right? Section 236 of the Admiral James W. Nance, right? Regulations or Authorization Act. Fiscal years 2020 and 2001. Executive Order 11295, 1966, and then regulations. So that 3004 is not here, unless odds are it's this one, just rewritten, updated. That's what I'm going to take it as, because I knew I didn't see this 304 here as a thing. And look, it even has it, Executive Order 11,337, which is not the same. We hold that on either interpretation of the complaint. What just happened? Well, something is lagging here. Look at that. It just jumped me somewhere. Wow. We hold that on either interpretation of the complaint, the court below was correct in refusing to reach the issue of criminal liability. There are circumstances under which the courts properly make exceptions to the general rule that equity will not interfere with the criminal processes by entertaining actions for injunction or declaratory relief in advance of criminal prosecution. I think this is important right here. I'm going to show this to to L. However, the Declaratory Judgment Act Title 28 USC 2201 is an enabling act which confers a discretion on the courts rather than an absolute right upon the litigant. And I give you more court case. The complaint filed in this case does not specify the sort of travel to Cuba appellant has in mind. Whether he plans to proceed to Cuba directly or travel there via one or more other countries, nor can we tell from the papers filed whether the government will, in the event appellant journeys to Cuba, charge him under 215B with leaving the United States on a carrier bound for Cuba with a passport not validated for Cuba. Leaving the United States with such a passport with the intent of traveling to Cuba, there before he returns home, leaving the United States with such a passport on a journey which in fact takes him to Cuba, re-entering the United States with such a passport after having visited Cuba, some other act, or whether it will charge him at all. Whether each or any of these gradations of fact or charge would make a difference as to criminal liability is an issue on which the district court wisely took no position, nor do we. For if we are to avoid rendering a series of advisory opinions, adjudication of the reach of constitutionality of 215B must await a concrete fact situation. And then it says compare another case. But the thing is, though, is they're saying they're not going to make a ruling because there's a criminal process going on first. So we won't make an equitable ruling because that's what he's here for. This is an equitable court. You guys understand that all these cases are under equity. All of them. But this is new right here, what they just said right here. The no. Well, doesn't it say equity follows the law, right? All right, the next case is, I haven't heard of this case, 1965. It's McEwan versus Rusk, 1965. Man, I got the hiccups or something. Action was brought against the Secretary of State and the Attorney General for declaratory judgment declaring invalid Secretary of State's regulations refusing to endorse passport for travel to and from Cuba. The district court refusing to endorse passport for the district court Friedman J held that restriction on travel to Cuba. So I'm guessing the judge is Friedman J held that restriction to travel to Cuba, the government of which is hostile to the United States, was within the inherent power of the president acting by the Secretary of State, and that the Secretary of State had power to restrict travel under the Immigration and Nationality Act and the Passport Act. The courts of appeals in the brief per curiam decision affirmed the district court's decision, pointing out that it was in line with the Supreme Court's opinion in Zemmel, which is the one we just read. I give you another case, Travis versus the United States, 1960, certiorari denied. Defendant was convicted in the district court for departing the U.S. without a valid passport. He had gone to Mexico and had entered Cuba from here. Even though they're not addressing it, right? Not yet, at least. I'm hoping that they do, right? Every one of them involve a country that was on the list, right? Though that aspect of entering and re-entering the United States from to and from one of these countries, right? That's why in that other case, they didn't charge him on anything when he left. And then on his return back, they can't really charge him for returning back because why? He has a right to return back home. That's why they appeal. I wish I would know the end result of that. I don't know. I'm going to probably shepherdize that at some point because all they did was remand it. Defendant was convicted in the district court for departing the U.S. without a valid passport. He had gone to Mexico and had entered Cuba from there. The Court of Appeals affirmed the court below, stating, this appeal is from a judgment and conviction for violating 8 U.S.C. 1185b and the regulations thereunder, sections 53.1 through 53.9 of Title 22, as amended. The indictment in two counts charged that on January 22nd, 1962, and August 18, 1962, the appellant knowingly and willfully departed the United States for Cuba without a valid passport for such travel. A jury trial was waived and appellant was tried by the court on an agreed stipulation of facts. Now you see what I'm saying here, right? They know he went to Mexico, but they don't bring that up. They're saying he willfully departed the United States, but that's not, in reality, he didn't. He willfully departed the United States for Mexico and then willfully departed Mexico for Cuba. That's how you really supposed to state that, because that is the truth. A jury trial was waived and appellant was tried by this court on an agreed stipulation of facts. Appellant is an American citizen. At all times pertinent and material, she did not bear a valid United States passport specifically endorsed for travel to Cuba. Appellant had knowledge of the provisions 8 U.S.C. 1185b and 22 CFR 53.2 and .3. Appellant made 2 trips to Cuba from the United States, both via Mexico. She obtained permission of the Cuban government to enter Cuba after her arrival in Mexico. On both occasions of her departure from the United States, it was appellant's intention to travel to Cuba. And that's the key. It will always be the key. Now, what happens, say you go to Mexico and you stay there for 6 months? And your intention shows that this is now your domicile, or residency, not say domicile, right? Because you're not changing citizenship or nothing like that, but your residency for whatever temporary purpose, right? And then you go to Cuba for reasons unrelated to anything that you were doing in Mexico or in the United States, just because you wanted to visit because you want to go visit. What do you think that would mean in terms of intention? Well, then again, I mean, on both occasions, she left the United States, right, with the intention to travel to Cuba. But like, if she departed the United States, stayed in Mexico for a year, 6 months or whatever, and then traveled to Cuba, well, that doesn't fall under the statute where it says to and from the United States, to and from one of the countries on the list. Zemo versus Russ, one we just read, was decided by the Supreme Court in May of '65 after this case had been argued. It was a civil action brought to compel the Secretary of State to issue a valid passport for travel to Cuba. The plaintiff there sought to enjoin the enforcement of the same criminal statute and regulations under which the appellant here was convicted. The area restrictions on the issuance and use of passports were held constitutional, and an authorized delegation of authority to the President and Secretary of State. The court declined to pass on the request to enjoin the enforcement of a right, because they ignored that. They say that equity won't take part until the law is done, right? Basically, that's what they said, right? This is different. She has been found guilty or whatever already, right? She already got hit. It stated, we hold that on either interpretation of the complaint, the court below was correct in refusing to reach the issue of criminal liability. For if we are to avoid rendering a series of advisory opinions, adjudication of the reach of constitutionality of Section 215B, we must await a concrete, so he's repeating himself, a concrete fact situation, right? Appellant attacks the statute 1185 as not authorizing area restrictions, being void as vague, and not being cited in the promulgation clause of the amendment to the regulations, which is referred to as the excluding Cuba regulation. Area restrictions have long been used as are recognized and valid. Section 1185 made it unlawful to depart for Cuba without a valid passport in violation of the regulation as amended. A reading of the statute and the regulations demonstrates the plain and unambiguous meaning to be that a person is subject to criminal penalties on leaving the United States for Cuba without a valid passport. That appellate knew this is agreed in the stipulation. The excluding Cuba regulation is an amendment and, as originally promulgated, made specific reference to Section 1185, Title 8. We consider the statute and regulations valid against appellant's attack. So she's losing. They ain't trying to hear what she says, and they cite. Like, they don't cite, we haven't read Healy yet. We did read all these other ones. Appellate contends hers was not a departure for Cuba, as she did not have that country's consent to enter Cuba. Appellate contends hers was not a departure for Cuba, as she did not have that country's consent to enter Cuba when she left the United States. Possible fact situations, including the one here, are suggested in Zemel. In our opinion, that appellate did not depart from the United States for Cuba without a valid passport in violation of 1185B. We adopt a portion of the opinion of the trial court. Right? Was it in Zemel that just he went to Argentina, then he went to Cuba or whatever? Was that the one? Because that's what it sounds like he's saying. Right? In our opinion, that appellant did depart from the United States for Cuba without a valid passport. In our opinion of the court, departure from the United States for Cuba is tantamount to leaving the United States with the intent to go to Cuba, which it is agreed the defendant did, and without a valid passport. If the effect of the statute and regulation can be circumvented by a citizen going to another country and there obtaining authority to travel to the excluded country, then the intent of Congress would be entirely obviated and the statute and regulation nullified. And so she loses, right? But man, I know that there's something more to this, right? I already know that there is. But we'll see if they have it here. Otherwise, I'll end up making a video. What the hell? Oh, man, my computer's lagging today. All right, on April 19, 1966, right, the opinion of Chief Judge Zavitz, right, so this is U.S. versus Laub, 66. District Court, Eastern District of New York has yet appeared in the Federal Supplement Advance Sheets through Volume 252, Number 3, June 6th. The following note appears in Law Week of April 26, 1926. I wonder what this is. Because they gave them certiorari. 34 Law Week. Let's copy this. Let's see if it comes up. Let's see if we get lucky. I doubt it. Yeah. Really? Look at the United States Law Week. I swear that's what this is. Look at it right here. Okay, so what is it again? 34, volume 34, 2576. 34 This is why I like using Court Listener. Oh, it's not here. Oh, it's not here. 12 to 32. What a lame. Maybe, let's see if it gives more than 32. Let's see. Damn. Nope. Jumps to 37. Oh, that's lame. Good try. Good try. There's other sites, of course, that I'm going to, that I'll end up looking it up at. But with that, I'm going to end this video since the next one is a completely different section. I do know that the appendix is coming up soon, so I don't know. There's probably like maybe 2 more chapters to read before the appendix. But with that, I'll call it here. Hopefully you guys learned something. If not, it is what it is. But like and subscribe and join my Telegram, Facebook. I mean, not Facebook. Actually, I do have a Facebook. I just don't do it. Don't use it. You join my YouTube, TikTok, and so forth. TikTok and in YouTube is literally the Butterfly Monkey Effect. That's literally what the name you'll find me under. So, all right. And on Telegram, my group is actually called Trust, and More Trust. It's supposed to be a trust law group, but because of so many differing opinions on a variety of subjects, it expanded to passport, citizenship, and all these other criteria, which was not intended to. I'm thinking about deleting them, because I want to get back to the root reason on why I joined social media in the first place, and that's trust law. So it is what it is, though. And with that, take care, guys, and I'll see you on the next one.